What's up, everybody? We're waiting for a verdict in the Crumbley case. I am going to be slammed this week, so I don't know when I'm going to be able to pop in and out. But it just so happens right now is right before it's like the calm before the storm here, as this afternoon it's all going to ramp up for me. But I wanted to get in and talk about where I'm at on this case. The more I've thought about it, the more I've read the comments, watched some more stuff on it from the trial. I think I've settled into how I would vote now, hearing everything and knowing everything. And that's kind of how this video is going to go, is I'm going to take you through parts of just kind of what the standards are, the evidence that I remember, how I apply it to the elements, and see whether or not the state proved the case beyond a reasonable doubt. It doesn't really matter what the defense did in a lot of parts, because the state has the full burden and the only burden. The defense has no burden. Now, if I think Jennifer Crumbley was lying and saying certain things that I thought the state's evidence was better, that would be a tick in favor of the state proving this case beyond a reasonable doubt. But there have been some juror questions, so I also want to talk about them as well. And you guys let me know if there's any other questions or a verdict comes in real time, and we will hop over there. So don't forget to hit that like button. Make sure you subscribe if you guys are new. I saw we got a bunch of subscribers in the last video letting me know they're new from this Crumbley case. I'd love to see that in the comments. So let me know if you guys are new from this case. But let's jump right in to the part of the closing I was actually going to show deals with the first jury question. So I think it'll be perfect to start there and discuss what exactly the state needs to prove in this case. And there are alternative theories, as we call them in the law. And the alternative theories are both involuntary manslaughter. Okay. So here are two theories: gross negligence in the performance of a lawful act, or gross negligence in failing to perform a legal duty. Now, you may ask, why charge alternate theories if you're the state? This is not like a lesser included, which I see a lot of people asking about lesser included. I didn't see them include any, so I don't think the jury can come up with any. So somebody said you're back in the old office. So this is my office. That other one's my home studio. So the majority of videos will still be done here. The members were there for the unveiling of my new home studio earlier this morning. But why does the state go under two theories? There's a couple different reasons. The one on the left is much simpler, right? That the defendant caused the death, and doing the act that caused the death, the defendant acted in a grossly negligent manner. That's simpler. A more complex one is the gross negligence in failing to perform a legal duty. They had a legal duty, knew of the facts that gave rise to the duty, willfully neglected or refused to perform that duty, and her failure to perform the duty was grossly negligent to human life. The death of the victim was directly caused by the defendant's failure to perform this duty. So, two kind of different standards. One might catch a jury's eye better than the next, but in reality, it's always helpful if you can have some way the jury thinks they're splitting the baby, or some way where they can be like, no, I absolutely don't think that, but I could be talked into this. Rebecca's saying negligent homicide. A lot of people are asking that. I think it would be better, but I think they're really going in on her actions and what she did and chose not to do specifically. So they felt like these were the better causes of action to go under. And I think they thought they had an egregious case here with egregious facts, and that's why they chose to go this way. So I think negligent homicide would be easier to win, but I don't blame them for going for this. And I'm not sure it would be a different verdict. I'll put it that way. I'm not so sure if they would have charged negligent homicide, it would be a different verdict than we're going to end up getting here. So if we're holding the state to their burden, did they prove the defendant caused death? I'm going to leave that one till the end because that's a difficult one for me. Now we're going to the negligence to perform a legal duty. Did the defendant have a legal duty to the victim? What is the legal duty that the parents had to the victims in this case? The students. Now, the state argued they have a duty not to give or allow to have or teach to use a firearm for their mentally ill and disturbed teenage son. So if we go with that, and that is the legal duty, okay? So the legal duty is not to be a good parent. It's not to do what we all would do. It's not to put them in the school we think and to give them the medication we think and send them to the church or don't send them to the church if we think that's what a good parent would do or one would be abuse. It's not to feed them a lot or feed them a little. Obviously, I'm not talking about starving your kids, but a healthy diet. Some people would say it was abuse. Some people say not giving a kid a healthy diet is abuse, right? Which is why I'm struggling to figure out what the government really is doing and making decisions on how parents should raise their kids and how far they should be able to reach in and say, this is grossly negligent what you're doing to your kid. Is it going to overreach into religion? There have been cases like that, giving certain medications or not giving certain medications to your kid that resulted in death. What about teaching them self-defense or not teaching them self-defense? Putting them in a big school, small school, specialized school, based on whatever their characteristics are. Putting them in mental health treatment, which I think a good state attorney could argue, see, they knew he had mental health problems. They even put him in treatment, and they still gave him access to this firearm. But in this case, they didn't, and they should have, the state argues. And I'm not disagreeing with that. I think it would have been great if they got him help. But I think the state still could have argued gross negligence. And what about the reverse? The defense could actually argue, which they did. They didn't put him in mental health counseling because they didn't think he needed it. Nobody told him they needed it until the last day. And so they're arguing we were actually good parents. We just didn't see the problem. So what did they know? What parts of the journal did they see or did they not see? I don't think they proved that they saw enough of it. I think they proved they saw the drawing. It's his specific gun that they gave him. And that to me is the biggest piece of evidence of notice. Outside of that, I'm not so sure calling your kid weird or saying he's depressed because his friend left or saying he's doing worse in school. I know I'm going to get some disagreements, and that's fine. That's the point. We're sitting here talking as jurors. I'm giving you my opinion as a juror. But I don't think those other things really rise to the level of, my opinion, that they knew or should have known he had severe mental health issues and therefore should not have taught him how to use a firearm. So I don't think I get there. But even if I do get there, and we talk about giving him access to a firearm, how do we define that as a jury? They said it was his Christmas present. They taught him how to use it at the range, or at least dad did, because he, even the state admitted, taught mom how to stand and things like that. Was it locked away? Was it in the box? Was the ammunition in a separate location? I think there were arguments on both sides. I think if it was my vote, I would say no, they didn't really give him access, unfettered access to it. But I could probably be convinced on that part that the answer is yes, mainly because James Crumbley secured his own firearms a different way in the gun safe, even with the 000 lock. And I think the state could make an argument that that's not appropriately storing them, but I might be able to be talked into that they did give him access to the firearm. But I am not convinced, and I don't think I could vote yes, that they knew beyond a reasonable doubt that he was mentally ill to the level that he should not be taught how to use a firearm. Because I know we've been over this. It's different than me. I was not taught how to use a firearm as a kid. Never knew where any of my dad's guns were. Same thing with my kids. And so, I mean, it is foreign to me, but I know that a lot of people are taught how to use firearms for hunting, for self-defense, whatever it may be. And I don't think personally I would have gotten there on that duty. And then obviously, did she willfully neglect or refuse to perform her duty? So this would be refuse to take him to get help. The state was saying she refused to bring him home from work. So Bella said, He asked his parents for help and said he was hearing voices. I think that honestly, I think that there is evidence on both sides of this as to what he did say to them, what he didn't, what they thought it mean, what they didn't think it means. And again, we may have a disagreement. You may think that that's enough, and they absolutely should know that he has mental health issues and should have no access to a firearm and should have been taken to a mental health counselor. And I think we could hash that out and we could talk about it. And I get it. And I think that's a plausible argument on the other side. But I can't in good conscience think that if there are certain complaints or statements made by a teenager who they go through a lot, that their entire life should change and they should be locked in a room and not allowed to do a ton of things. Because another hypothetical was posed to me by people on Twitter or in my email. And it's, if this was a kitchen knife, obviously we heard that in closing argument from the defense. Would it be different if it was a kitchen knife? I think the answer is clearly yes. You don't have a duty to, again, lock your child in the room and make sure they never go into the kitchen. Okay? I think we can all agree on that. What if it was a car? 15-year-old son, teaching him how to drive. You buy the car for him in your name. He's going to be able to drive it in a year. He knows where the keys are. He takes it, steals the car, drives it through the school. I don't think we have these charges then. I think we could in the future apply it similarly. But I think it's tough. And again, Michael Marin, you can't foresee someone doing this. And again, is him saying, I heard voices or certain things like that enough for you to foresee he might do something like this? That's the tough part to me. That's the really tough part. So the jury asked, their first question was, is it both? Can it be either or? And the judge answers, it can be either or. And they read them the jury instruction of alternative theories. To take it a step further, I'm going to go for the causation. Okay. So in order to win here, the state has to prove, I don't know why this box is now covering up. There we go. This causation argument. There may be more than one cause of death, okay? Because Jennifer Crumbley's actions have to directly cause the deaths. Doesn't have to be the only cause, but it does have to be a direct cause. It is not enough that the defendant's act made it possible for the death to occur. In order to find the deaths of Ms. Baldwin, Mr. Meyer, Ms. Juliana, Mr. Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act, not the shooter's act, okay? So again, we have to apply the defendant's actions to this. They bought him a firearm, taught him how to use it, potentially gave him access to it, but they didn't put it in his room. They didn't just give it to him. It wasn't in his drawer. So there was at least some barrier. It was in their room, their box, their drawer, not locked. She said it was locked. Again, I think the state proved that was probably a lie since the lock thing she was talking about was still in its original packaging. They said the bullets were separate. So there's at least something there. And that's what I'm saying about taking him to one appointment. Just because there's something there doesn't mean the state wouldn't argue that this was still grossly negligent. So the defendant's action of buying it, not giving it to him, very lazily keeping it from him, but he did have access. And then their actions of not doing something about his mental health or not recognizing it or realizing it or, I don't know, putting him in some kind of facility. Is that the line? Did they have to do that in order to absolutely prevent this? Because who's telling you didn't know the 000 combination and could have just gotten one that was locked? It has to be the necessary and natural result. And the more I think about it, the more I just don't think I could get there. I don't think I could get there beyond a reasonable doubt in this case. And then gross negligence. It's more than careless. So was it careless that she didn't take her son home from school? Was it careless that they didn't lock up the gun even though it was in a separate room? Was it more than careless that she had an affair and didn't spend more time with her son? These are the questions we'd be asking ourselves if we were in the jury together. And Lingo said, okay, so you got me thinking now. It's all this is. Not trying to convince anybody. And if you would vote guilty, I respect that. And I think if we sat in the room, we'd sit here and hash it out. And we'd talk through. And maybe you would say something that would make me think, you know what, I could get there. And so again, nobody here is arguing that she wasn't careless. I guess that's not true. The defense is kind of arguing she wasn't careless. If I was back in the jury, I would say she was careless. Jenna said 100% careless. Yeah, I agree. She is careless. I would not argue she wasn't careless if I was sitting back there on the jury. But carelessness is not enough. It has to be more than careless. She had to know of the danger to another student. So she had to sit there. Basically, what they'd be saying is she sat there, saw her son, knew he was a danger, and was like, you know what? Go back to class. I don't want to take you home. She had to know that the result was likely, naturally, and necessarily going to occur. She didn't plan it with him. He didn't tell her his plan, and she said, okay, but she knew based on everything else that this was going to occur, which is why I thought it was so important that the school counselor and the teacher that locked eyes with him in the hallway both said they were surprised and wouldn't have expected him to do this. Teachers spend a lot of time with kids these days. Was this foreseeable? Did she know he was going to do this? And I just can't get there based on the evidence and even based on her testimony. Yes, she wanted to, I think she exaggerated about how hypervigilant of a parent she was. I think her defense attorney did too. I think there were some things over the top, some hyperbole. Second, that the defendant could have avoided injuring another by using ordinary care. Sure. Put him in a facility. That would avoid it, right? Is that what we want to happen? Lock the gun more appropriately? Sure. Get him counseling? Sure. I think there were ordinary things, ordinary care she could have done to prevent injuring. Number three, I absolutely think there is. And she failed to use ordinary care to prevent injuring another. I think I could be convinced of that. 1 and 2 are the difficult parts for me. Susu said she was a terrible mother, but I could not vote guilty. And I think this is what, if our chat was in there, I think these are the conversations we would have had. These are the conversations we would have had as a jury. I don't know that the jury's having these conversations. All right. So that was the part of the jury instructions I wanted to discuss. I'm going to go through some of your questions. And then we're going to talk about the second jury question. And we're going to run through some really interesting things. I've got another clip I want to play about that. By the jury asking the shooter testimony. Oh, wait, hold on. I'm going to save that for when we talk about the second jury question. Cindy, was Ethan ever legally diagnosed with mental illness? Not that I saw come out in trial. Francine, Peter, why do you think that the parents in Columbine were viewed as victims where these parents are being villains? Could it be consideration of SES? I don't know what SES stands for. But what I will say is, I don't know the details are behind Columbine, but I think there were certain facts. This is not just, they were great parents and that something slipped through, or he broke into their gun closet or something like that. I do think that there is at least a gray area here worth discussing, although I'm saying which side I end up falling on. Audrey, would she be able to be found guilty with time served and be released? Will the judge do the sentencing immediately after the verdict? I don't know the sentencing guidelines in Michigan. My guess is she would have some minimum time she'd have to serve, but I don't know for a fact. Rebecca, do the parents need to be taught beyond a reasonable doubt? Do parents need to be taught beyond a reasonable doubt? I think everybody should be taught that, but I don't really think like going through your life using that burden very often pops in. So I'm not sure what this was in reference to. Fox, if this was a police officer who didn't lock up his gun, regardless of whether it was a kid's gun or not, the officer would be guilty. I don't think so. I think if it was at his house, on his nightstand and he lived alone and somebody broke into his house and took it, that's not really foreseeable. I think there are a lot of it depends facts we'd need to know. Fat Fairy. Ethan was tried as an adult, so why is she charged for parenting failures if he is not considered a child in the courts? So there's nothing here about her being a parent, right? Now they're using it as her duty, but again, that's where slippery slope arguments come in. This is not just a parent-child relationship. I think that's how they're using it again with the duty, but this is not a cause of action or a line of thinking that would be limited to parents and children. Clever nickname. Teens make permanent decisions to temporary problems. We have to ensure we reduce the risk by all means necessary to ensure they can't be so dangerous. See, as a lawyer, this type of verbiage scares me. By all means necessary. If I locked my kid in a room with no lights and no toys and no computer and nothing, nobody else would get hurt. Do we really want to do that? I think the answer is no. I think we got to balance, right? We got to balance how we treat our kids, how we raise them, how we teach them responsibility and grace and dealing with conflict, dealing with problems, dealing with anxiety and depression and pushing through. All that stuff's really important. But if they never feel any of it, how are they going to know when they react to it? It's like when somebody's parent, I had a friend in college who their parents never let them have fast food. And they came up and they didn't gain the freshman 15, they gained the freshman 50 because all they did was eat McDonald's and Chick-fil-A and just gorged. So I think we have responsibility as parents, no doubt, to our kids. But government overreach and telling me how to reduce risk by all means necessary, I'm not interested in. And clever nickname, I'm not saying that's what you said. I just mean that's kind of where some lawyers' heads go with slippery slope arguments. Jay Risto, will you comment on the prosecution delving into her personal life and affair? Again, that's just trying to make her look like a bad mom. I think that's it. And I think it could backfire potentially. Midwest, if found guilty, do you think this would be used as an example? Yes. Lauren, can you give another example of a direct cause? Sure. You get in a car accident, you T-bone somebody, and they hurt their back and they have to have surgery. The surgery goes bad, so they have to have a second surgery. What is the direct cause of that second surgery? Well, the first surgery going bad is a direct cause, but also your car accident is a direct cause. Because if you would have never T-boned her to cause that lower back injury, she would have never had to have the first surgery, which then in turn required the second surgery. So that's two different direct causes for one thing. American Anna. Peter, why did none of the evidence from his treatment as a little boy, his neglect started way, way back. He had to deal with his dog he loved. Once it passed by himself, he cried out for years. I'm not positive. I just watched what came out in the trial, so I'm not positive about this. My guess is if the state could have gotten it in, they would have. Evelyn, I'm a mental health professional who works exclusively with children and teens in acute psychiatric crisis. Almost all parents go through a period of denial when their child should start to present with mental illness, especially as teens. So what's the right move, right? Start treating them earlier, maybe before it's necessary, because then at least it keeps it from going too far. How do you get parents out of denial? Maybe I would be in denial. I don't know. I appreciate this comment because I think it's a real thing. Mercy Cat, if she's found guilty, then should therapists, doctors be charged going forward? There's more kids who've done this crime who were in therapy on psych meds. So again, the doctors would say they were doing their job and it still happened. So there's really nothing more they could do. The point is the parents here did nothing and then chose to do even less, basically disregarding obvious signs. Michael, curious about prosecution's double standard in shooter's trial, wasn't mentally ill and was an adult. Parent's trial is mentally ill and is a child. So there's a difference. I saw some people talking about this. There's a difference between insanity defense and incompetent to stand trial versus suffers from mental illness. You can suffer from mental illness and still not be legally insane or legally incompetent. And my guess is that's where they're drawing the lines. And we've talked about those lines in other cases where somebody's arguing insanity, meaning they were insane or had a mental break at the time and didn't know right from wrong or what they were doing or the consequences of their action, versus legal competence, which is understanding what's going on, being able to help in your defense, talk to your defense attorneys, and go through the process. So those things can still be true, even though he was suffering from mental illness, which they're arguing in this case. John, with gun laws being a divided topic, does it make more sense to add law? I'd maybe argue that more law restrictions would not benefit. I don't know. Yeah, usually more laws don't help. Rebecca, harm to himself or others. That's what it looked like. That's what's looked at. Gingy Probs, uncivil mention 2X in appeals court ruling that to prove guilt, the defendant had to know the day of the shooting and chose not to act, but that's not explicit in the jury instruction. Thoughts? I mean, I think from what I read, that's how I would argue it if I was the defense. Now, a lot of times they'll give standards like this. You make verbiage accurate enough, but if it's kind of confusing to the jury, you may never find out because we don't know what they go back there and talk about. Now, if the verbiage doesn't meet the standards set by the Supreme Court, that will absolutely be an appellate issue. And that's this type of thing is why I think it's so difficult to get beyond a reasonable doubt for this case. Melissa S., school calls and shows you that math paper and you know he has access to the gun and do nothing. How are you not responsible? Never mind anything else. I can't get past that. And that's the crux of the entirety. That's the crux of the entirety of the argument, I think. And I think one of the, as horrible as this sounds, okay? And if you see other things and they talk about mass shootings and things like that, this was one person. The gun was written in a different spot. It was horrible. It was concerning. I probably would have taken my kid out of school. I mean, it's hard to put yourself in their shoes because I would never buy a gun for my kid. But I agree. This would be part of the discussion. Nirvana, how old was Ethan when he did this? I believe 15. Fox, if the police officer was the parent. Again, I think this is almost a level further because there's evidence that they bought this for Ethan. Kayla, had they been able to prove he reached out for help and made known he was struggling, this would be an easy case. Can we convict for he said, she said? No, we can't. Well, we can convict for he said, she said if you think only one of them is credible beyond a reasonable doubt. Class Act Beauty, I'm really hoping for a not guilty. I have watched this whole trial and it's really confusing. I love your feedback as always. Thank you. Thank you, Class Act Beauty. Nick, is there a double standard, however? Where do we draw the line? Should the parents of underage gangbangers be held responsible for inner city Detroit? I mean, I would argue they might have more knowledge a problem may happen, but do they have control? Do they have the same control? What are they supposed to do? Maybe some of them are in fear. It's a case-by-case basis that we have to apply this entire situation. All right, we've got a ton of questions. So let me hop back in. Let's listen to this second. Let's listen to this second jury question. And then discuss a few more questions and things that I wanted to talk about with you. Oops, this is not it. All right, here we go.
The question is, can we infer anything from evidence or witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who could answer how it specifically got the gun?
So basically, how can we figure out, or is there a way we can evaluate any evidence that the prosecution did not put on, like witnesses they did not call, like the shooter, and any more information about how he got the gun? Because there's a gap in the story. What did the parents do to prevent him? The state is filling holes with inferences. The defense said it was put away, it was locked, the bullets were somewhere else, and the state has the burden to prove how all of this happened and that the parents were a direct cause. So let's hear them discuss how they think this should be argued. By the way, the first jury question about the alternate theories was a big plus for the state. If I was the state attorney, I'd be like, yes. Okay, they're going to pick one of them. They're not going to pick both. That's fine. They can't pick both. It's alternate. So I'm glad that they're thinking. I think they're going to figure out one of these fits and they're going to pick one. This question, on the other hand, is incredibly good for the defense. And I think it benefits the defense that they're thinking about this stuff. Why didn't we hear from some people? Why didn't we fill those gaps with actual evidence and testimony? And if those gaps weren't filled, is that a reasonable doubt? And you'll hear what the defense attorney thinks when you hear what jury instruction she wants read to the jury.
The answer is no, right?
Correct.
Do I need to refer them to, I need to send them 2.9 or 3.5?
I believe you need to send in 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears.
Very smart of her. She ain't no dummy. She's like, Judge, I think we should also refer them to the fact that a reasonable doubt could be a lack of evidence, which is exactly what this would be. The state didn't bring enough evidence to fill the holes. Now, they don't end up reading it, but can't knock a girl for trying. And I think that's exactly what she should have done, and that's exactly what she should have asked for. And that's why you make those arguments in closing.
They're asking about lack of evidence.
No, they're asking if they can fill in the blanks about why the shooters are there, aren't they?
Yeah. Yes.
Then we can't let them fill in the blanks.
I agree with that, but I think it goes to, they're asking essentially why the shooter didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Now, the judge would never do that because that's an argument, but she's making a great point, and that's why I think it's good for them, because this is something you can infer from the jury's question to answer Trendy View's question. And where's that other question? Kelly, by the jury asking about the shooter testimony, how do you feel they're leaning? I don't know. I think based on these two questions, I would have felt they're leaning opposite ways, which makes me think they're thinking. They're having the same discussions we're having right here, which is why I find this really interesting. Thank you, Rebecca, and to Candace and Donna and everybody gifting memberships today. That's awesome of you guys.
Just again, you can't guess what they're thinking. You just answer the questions.
He's also right. Can't guess what they're asking, just answer the questions. But by answering the questions, you got to guess what they're asking.
I'm sorry, which instructions did you?
I was thinking, well, these are preliminary instructions 2.9 and or 3.5, was it?
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9, and what was the other?
3.5 maybe. I don't think it says. I can bring them in and read 2.9 and 3.5 today. 3.5 talks about evidence, including the sworn testimony, witnesses, exhibits, and minute evidence, anything else I tell you to consider as evidence.
It seems on point, Judge.
I have no objection to 2.9. I am just making a record that I'm also requesting 3.2.
Okay, do you want 2.9 or 3.5? Either one of those. I'm trying to keep myself to answering the question that they asked. They have an instruction with them about reasonable doubt. They've heard it a bunch of times. They do not have in the jury room 2.9, although we do have 3.5. So,
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 probably appropriate given the question.
that's what I'm going to do.
Thank you.
I'm going to bring them in. Okay.
Thank you, Judge.
I'm sorry.
I'm going to bring them in.
So while we wait for the jury to come in to hear how the judge reads them this instruction, Sheila said SES means socioeconomic status. I think Columbine was different because it was one of the first major shootings of its kind. Now shootings are thought as more normal than they were. I don't know about more normal, but maybe more foreseeable. I think it would have been really hard back in Columbine to prove foreseeability. Unfortunately, I think it's a little easier now. Gringa said teen brains are not fully developed. If you can't be trusted to vote, serve in the military, buy alcohol, or rent a car, you should not have access to a gun. I agree with you, but what's the definition of access, right? I don't think there was any evidence that they just let him have unfettered access, like he took it by himself places or put it in his room or in his drawer or something like that. Do you mean never access, like never touch? I don't know. That's tough. Midwest, if the mom's not guilty, what do you think about the father? I think the mom's case is about 10% better than the dad's because they have arguments like it was the dad and the shooter's thing. The dad taught him, the dad and him, it was kind of their thing they bonded over, not mom and him. But generally, I think it's going to be the same. Oop. All right, here we go.
Bringing them my term anyway. So, you asked, can you infer anything from evidence of witnesses that the prosecution did not bring? The answer is no. And you say specifically not bringing the shooter or other people who didn't answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the beginning of the trial. 3.5 says, when you discuss the case and decide on the verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not.
So she's basically reiterating the only evidence you can consider is the evidence you have. Don't consider what you don't have. Now, as a criminal defense attorney, you're like, but the lack of evidence. You can consider the lack of evidence. So hopefully the jury doesn't get confused and think they can't consider the fact that that's lacking, or if they need more evidence, maybe that's a reasonable doubt. So Mandy, I totally understand where you're coming from. Totally understand. And then we have a bunch of comments like Kelly's, where people are on different sides of this. And again, I appreciate the respectful back and forth on this. And, Jose brings in a point. If the parents are responsible, they should be praised. They shouldn't be praised for kids' successes. I mean, I think that's a little bit far, but I think there are people that will have these types of thoughts. And Kathy said, I pray she's found not guilty. This trial has been a teachable moment for parents. I think that would be a good result, right? That regardless of guilt or innocence, parents do learn here and are looking for signs. Ravina said, I've raised 8 boys. I didn't hyper-focus on them when they were teens and started finding my own hobbies. I would have watched close after all those losses, though. I agree. And that's the point, is like everybody's going to use their experience. Even the criminal defense attorney, she used her experience in trying to explain where do we draw these lines, and it's just not here, basically. And the state wants to say this is way past whatever line you would draw, because that line is kind of a gray area. American Nana said he had been crying out for years, maybe because use of his appeal, they couldn't bring all that in. All these mental findings were in the Miller hearing. Evelyn, did the school safety plan with the parents to immediately secure the firearm in the house? Not that they were not told to do that. They were not told to take him as far as they were concerned. I think the school said they did say to take him home, but again, you can kick a kid out of school. You're allowed to do that. Like, it sucks, but you can do that. So it just is a little fishy to me on how all of that happened. And now hindsight looking back, I'm sure everybody wishes they did something different and wishes they did more. But at the time, what was foreseeable? That's the question. And Azam said, how about teachers? Would they be prosecuted too? I hope not. I think in this case, the school and the teachers at least didn't know everything the parents knew. They didn't know he just got this gun that he drew specifically. They didn't know about the loss of the friend, things like that. So the school does have less liability, I think, than the parents, although there is liability all around. And Sav asks, a different charge that will make more sense legally, civil, take their money. That's what I think makes more sense legally, personally. Because again, that's only 50.1% that you have to prove they caused this, not beyond a reasonable doubt. So some of the gray areas are a little bit easier, like how he got the gun and things like that. All right, so let's listen to the rest of these. There's 10,000 people in the chat. Holy cow. Hit that like button, you guys. If you haven't already, let's get to 10,000 likes, subscribe, all the YouTubey things. We're going to listen to the judge read the rest of the jury instructions, and then I'm going to play another clip that I think is pretty eye-opening.
Consider those things in deciding the case. Make a decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right. So I'll have you return to the jury room.
All right. So they return, I'm bringing it up to date, and there's nothing. Okay. So we know that the jury wanted to hear from the shooter. They wanted to know how he got the gun. Was he given this, unfettered access? Should they have done more? What did they do in the first place? Fill the gaps, fill the holes in what happened that day. So in my mind, who do you guys think if the shooter would have testified, who do you think it would have benefited more? Which, the state or the defense? So Abby, I don't know if I'd say no one, okay? I don't know if I'd say no one, but I think that this is a reasonable argument and therefore potentially a reasonable doubt that looking at that picture, maybe their mind did not go immediately to mass school and instead self-harm. So it looks like a split. It looks like a split. Somebody asked what I'm drinking. Coffee. My iced coffee. So let me play, because we did a video on this already. But let me play this again, okay? This is Ethan Crumbley in his sentencing where he makes a statement. And when he made this statement, I thought, wow, if he testifies, I thought it would be a sure not guilty if he testified. I don't know how you convict the parents if an adult-ish person testifies like this, okay? And this is why the mom wanted to call him.
I'd like to thank you for letting me speak, Your Honor. You're all here because of me today, what I did. My actions were because of what I chose to do. I could not stop myself, but I am the one who led to why we are here today. I do not diminish any ability to anyone who could have stopped me, of anyone of a school or parents. They did not know, and I did not tell them what I plan to do, so they're not at fault.
I'm going to back it up again because, again, I think he misspoke, but maybe the prosecution could argue him saying, I do not diminish what they did as, oh, see, he's saying I'm not going to diminish their fault in it. But then he says, no one else is as at fault. No one else knew.
I am the one who led to why we are here today. I do not diminish any ability to anyone who could have stopped me, of anyone of a school or parents. They did not know, and I did not tell them what I plan to do, so they're not at fault with what I've done. I am a really bad person. I have done terrible things that no one should ever do. I have lied, been not trustworthy. I've hurt many people, and that's what I've done, and I'm not denying it, but that's not who I plan on to be.
So I think if he comes with some testimony like that, and if you guys want to hear it again, we can play it again and break it down further. But I think if he came with some kind of testimony like that, I would be pretty adamant about not guilty. But that's not in evidence, right? It's not in evidence, which is why, based on what we have to consider, I think it would be a discussion, even though my vote at this point would be not guilty. I'm not predicting that's what they're going to do. I don't know what the jury's going to do. I could see this one going either way. Everybody always thinks there's going to be a hung jury. I don't think there will be a hung jury here. It's possible. But this was really eye-opening to me to watch back after hearing, and I watched it back again after hearing that jury question about, can they hear from him? I hope the answer to this is no, but did any of them go and do online research over the weekend? Did any of them see this or hear this? Joanne, do you think it will be a long wait for the verdict? She wasn't a great mom, but I couldn't vote guilty to this. And now a civil case, heck yes, I would say guilty or liable. I don't know. It's always tough for me to predict. I would say it's going to be sometime this week. But it could be, if I had to put a day on it, maybe tomorrow, but I don't know. Fox, she didn't attempt to call any counselors that day for an appointment, but was going to her riding lesson that night. If it happens the next day, would that make a difference? Maybe, but my honest opinion is, from a defense's point of view, that shows she didn't think there was a problem and that the school was not alarming enough in that meeting. That's what I would argue. Again, you could look at it and say, oh, clearly she knew he was going to do something like this because that's the standard. She knew he was going to do something like this and still would rather have gone and rode horses because she didn't care about any of those other kids at school. I don't think that's the case here. That's my feeling on what I see from the evidence. Abby, the prosecution's cross seemed really lacking on the gun issue. They didn't hit her hard on the gun issue at all. That's a big sticking point for me. My guess is they'll go harder against James Crumbley than they did against her with the gun issues. Kate, why is this about more than they didn't share with the school that the gun existed? They didn't look in the backpack and didn't take him out of school. What processes and procedures should be put in place that they broke, right? So they don't have to tell the school about them getting him a gun. That's not illegal on its own. It's all these factors we're putting together. Should they have gone and searched the backpack? I think yes. I think absolutely yes. And is that enough? The fact that they didn't do that, is that enough? I mean, again, if you believe that, and maybe you believe they didn't care. They were like, we don't care if he's got the gun here. We don't care. But again, I think some other people would point to that picture points more to self-harm than anything else. I don't know. I think these are interesting discussion points. Let's say they find her guilty. Can the jury sentence her to time served since she's been in jail for 26 months already? The judge sentences. Mandy, this isn't a gun or gun access issue. This is a new societal problem and a mental health problem. This didn't happen in the past, and there were less gun laws. Connie, please answer this. Is it fair for the parents to be convicted of this even after the son has been convicted as an adult? So we went over this already. There's no like parental element to this. It doesn't only apply to parents and children. So, I mean, yeah, this is just negligence that the natural and necessary result of what you did resulted in death. And you had to know that. It doesn't just have to be guns. It doesn't just have to be kids and parents. If found guilty, will the school as a whole be next? I haven't seen anything on that. I don't know what it would be like trying to get some kind of criminal liability from the school or like the government. I'm not sure how that would work. I don't expect to see that. I don't expect to see something like that. Amy Z, if mistrial, could her bond be lowered? It could be, yes. Because again, one of the elements of the bond is the evidence against you or the strength of the evidence against you. Although her being a flight risk is a pretty big issue based on the obvious discussion points about her fleeing. One reason for such a high bond was prosecutor make it seem like she was fleeing, which wasn't proven at all. So they don't have to prove flight beyond a reasonable doubt. I think they had more evidence than you would have in your normal case when you bring it to a judge that they are potentially flight risks. Janet, eye-opening is the video he recorded the night before. Is that the one on his phone that we don't know that his parents saw? I'm trying to just stick to what's in this trial, but I watched the sentencing before the trial. Keeley, interesting the jury wanted to hear from him. I mean, I think that makes complete sense to me. School has governmental immunity. That's what I would think, unless they go for after some individual person like they did in the Parkland case. But I would think the same thing. But sometimes you can get around immunity, but I don't think criminally speaking in this situation. C. Silva, if a parent is negligent, they should be held accountable for their child's action. If these parents are not negligent, then we need to define what negligence is. Christina, Peter, could the defense have used this video as part of their case in chief? No, it's hearsay. That's the tough part. Amanda, sorry if this has been said because the two trials are severed. I'd be more inclined to vote guilty on the dad because he brought the gun. It doesn't seem like she would have bought one for him on her own. Yeah, like I said, I think the dad's case is maybe 10% worse than hers or more likely of a guilty than hers. Lori, she literally had 2 hours before it happened. I don't know if you're saying that's a lot of time or a little time, because I would say that's a little time, but I think there would be people on both sides of the chat and maybe both sides of the jury answering this different ways. Joel R., if she is found not guilty, what's the chances they drop the charges against James? I think they would still go after him because, again, I think his case is better for the state than hers. All right, I'm going to play this one more time just so we can know somewhat what the shooter would have testified to in this trial. We can imagine what cross-examination would have been like and things like that. But let's hear this one more time, and then I'll answer a couple more questions.
Me today, what I did. My actions were because of what I chose to do. I could not stop myself, but I am the one who led to why we are here today. I do not diminish any ability to anyone who could have stopped me, of anyone of a school or parents. They did not know, and I did not tell them what I planned to do, so they are not at fault for what I've done. I am a really bad person. I have done terrible things that no one should ever do. I have lied and not trustworthy. I've hurt many people, and that's what I've done, and I'm not denying it, but that's not who I plan on to be.
All right. So that is Ethan Crumbley's statement. John, why don't you throw a poll up on where people would vote right now, guilty or not guilty, while we answer a few more questions. Yes, incredibly hard to listen to. Bella, I have a question. Do you think it's possible that he could have done it with one of his dads if he didn't have his own? Could he have done it with one of his dads? I don't know. Katie, why do you think / do we know why the mom was tried first instead of the dad? Does the order matter? I think the order matters. I think it's better for whoever goes second, but I don't know the answer as to why mom was tried first. I don't know if anybody else knows that answer, but they could throw it in the chat. Arena, this judge said she doesn't see what question the defense could have asked EC that he wouldn't plead the fifth to. What about his statement? So again, now that he is appealing his sentence, he wouldn't admit to this stuff. He wouldn't admit that it was all him and that he was so horrible and all that stuff. So, and he wouldn't admit that he went and got the gun and things like that because all that stuff could be incriminating for him. So that's why it's the fact that he's appealing. Rachel, do you personally think if the verdict is guilty that it's more political rather than true gross negligence? I don't know that it's political for this jury. Do I think that it will be politicized? Yes. I think regardless of what the outcome is, it will be politicized. All right. Blue Lagoon. In this case, I'm so happy we have gun control. But in general, the government seized all weapons. So what you see now are illegal weapons. Yeah, I mean, all this stuff is hard because I think if you really critically think about it, there are arguments on both sides. There's no perfect solution. For me, most governments eventually show that they don't have the answers and they don't necessarily handle it right either. So it's tough whenever you give up rights. It's near impossible to get them back. So it's a really tough discussion back and forth. And I mean, we're seeing in some cases like Delphi where it can be really scary out there. It can be really scary and you can get railroaded. Thank you, Bobby C, for gifting some memberships. So Lily thinks that the parents shouldn't be liable because he's an adult. It doesn't preclude them from trying him. So right now we're at about 65% not guilty, 35% guilty. I think that's about where we've been. I think we were like 58, 59, somewhere around 60% not guilty before. So again, Trip show, no gun equals no casualty. So that's just across the board. My guess is questions like this were asked during voir dire. And if a juror said yes to this, like the fact that a gun is involved, then she should be guilty, that they would not be on the jury. But I don't know. Before this live, guilty, now not guilty. Love your input, Karen. I think that just shows we're open to discussing it, and it's not a slam dunk either way. I really don't think so. I really don't think it's a slam dunk either way. Peter, what made him snap in that moment? I don't know. But if he snapped in that moment, nobody could foresee it. I'm not sure we have a guilty verdict here. Amy, the prosecutor Karen is going to run for governor. Charges were definitely political, not with the jury though. Yeah, I don't know. I don't know what everybody else is doing. I do not think the jury is thinking they're making a political statement. I hope not. And again, a lot of that was kept out of the closing arguments. Marty McFly, did Peter ever directly answer the question on the title of the video? Yes. Does anybody on the stream want to tell him what I said? I said at this point, my vote would be not guilty. And the only thing that could change it would be discussion with other jurors and how they saw it and if they could really convince me towards the other way. But I do not think there's enough to prove these elements beyond a reasonable doubt. Rachel, can they use Ethan's words for her appeal? No. Well, they can make arguments that maybe they were unlawfully kept out or suppressed or secluded and they should have come in. And then we think this would have happened if they would have come in, but you have to stick to what happened in the trial in your appeal. Cassidy, if found not guilty, does her former employer have to give her a job back? No, they do not. Will she get out today if not guilty? Yes, if not guilty today. All right, let's see. So somebody said he didn't snap at that moment. He planned it. A lot of interesting questions in here in the chat. And I appreciate the tone. We always keep it respectful. And we disagree gracefully with people on here because I think we learn more when we do it that way. Being dismissive and condescending to me doesn't really get you very far with people usually. Somebody said, if hung, does she go back to jail? Can she get bail? Yes, she goes back to jail. Yes, she can still. I think she's on $500K bond. It's potential it could be reduced, but probably unlikely. Tingles, does the son's statement at his trial not seem different than the message he sent and his journal? Would this not be so due to his getting help or the massive time out prison for hours? I don't know the answer to that. The Crumbleys basically said he was kidding or that wasn't actually true. He was being dramatic in his journal or whatever. So maybe he would say that he was just trying to get attention and then, he did this, but it wasn't his parents' fault. I don't know. Or he had joked like that in the past. They never could have known what was happening. I don't know, right? I don't know. All I know is in his words, he said under oath, it's all my fault. I don't blame anybody else. Maybe the state could have gotten, a good cross in to make it seem like that wasn't actually the case and he was just trying to protect him now. Blue Lagoon, by the way, very impressed with your updates. Thanks, Peter. Greetings from Belgium. Blue Lagoon Studios. Thank you. Nikki Mick, if she could foresee he was a harm to himself and others, then why would she buy him a gun since she could have been a victim point for defense? I think that's it. It's a big part of this, a big argument. Amy, it's sad to me. She's presumed innocent and has been locked up 23 hours a day for over 2 years. It is really sad. But again, especially it's a violent crime. And it's pretty specific to her situation, but Daryl Brooks was let out and we saw what he did. So there's arguments on both sides of bail and bond reform. And that's why we have the analysis and balancing act in place of, are they a danger to society? Is there a lot of evidence against them? Are they a flight risk? Are they a risk to do this again and reoffend? And the judge has to do an analysis and set an amount of money that hopefully would make them obey when they're out and show up to court and not flee. And it's a really tough analysis, but I agree. It's really sad. Matt, Peter, any recourse if she's found not guilty, given she was locked away for 23 hours per day? She looked defeated and broken. She has culpability as a parent, but not legally. No, because there is probable cause. I shouldn't say no. Probably not, because there is probable cause for her arrest. The analysis was done again to give her a fair bail amount that she couldn't meet. So all of the steps and requirements, all the boxes were checked, and she ended up, unfortunately, if she's not guilty, in prison for a long time. No. Daryl Brooks is not out, but he was out on other charges on bond when he committed his crimes at the Christmas Day parade. He's not out now. Welcome to all the new members. Let me see here. So unlikely she would ever get compensation because they do have enough to arrest her. It has to be fraud. There has to be other issues, and usually the government's not the one at fault for that, unless again the police or state attorney's office are doing something wrong. But we've had cases where they were given fraudulent information. We were able to sue somebody else for getting somebody arrested, but not law enforcement. Nirvana, is this the first set of parents being tried on guns? It's the first high-profile one that I can remember. I'm not sure if any others have happened. Okay. I'm going to give one last check to make sure no jury questions or anything like that in court. I see nothing. All right. We're at about an hour. This was a really interesting conversation. I learned so much from you guys every time you come, every time you comment, every time you ask questions. So I can't tell you how much I appreciate that. Appreciate how much you show up. Keep it civil so we can actually have these discussions and arguments, because they go nowhere when people are nasty to each other. So I respect you guys so much for that. Make sure you hit that like button and subscribe to our page, because whenever a verdict comes, I will be jumping on. I don't know if I'll be able to stream it live, but if I don't stream it live, we will have a reaction as quickly as I can get on afterwards. So make sure you subscribe and hit that reminder bell so you don't miss it. But for now, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.